And good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, and thanks for joining us here on the program where we cover the most interesting live trials and legal stories in the news today. And we have a lot to cover, so I want to get started right now on what's on the docket for today. Let's go. We want to talk right now about the Claudia Herig case, really exciting one that we're covering out of Ohio. And here's another special report about this trial.
A woman is standing trial in Ohio for allegedly murdering her husband and fleeing to her home country of Brazil. Claudia Herig faces an aggravated murder charge for the 2007 shooting death of Major Carl Herig, a decorated war veteran and Air Force pilot. According to the affidavit, a neighbor saw Claudia leaving the couple's home on March 12, 2007 around noon in a silver BMW registered to Major Herig. The car and Claudia had not been seen at the residence since. After missing a scheduled flight assignment, family members of the major called the police. Upon entering the home, investigators discovered Carl's body laying face down on the floor with 2 gunshot wounds to the back of the head. Claudia was born in Brazil in the 1960s. She was naturalized as an American citizen in 1999 during a previous marriage. Claudia married Major Herig in Vegas in June 2005. But the couple seemed to be dealing with issues in their marriage in the 2 years they were together. According to a police report, Carl told a colleague that his marriage with Claudia was poor from the beginning, and he was planning on moving out of their home the day Claudia vanished, 3 days before Herig's body was discovered. The victim's father also told police that he was worried about his son because of marital problems. Investigators also spoke with Claudia's ex-husband. He described her as abusive both physically and mentally to him during their marriage. That's according to police documents. The missing BMW was discovered a day after the body was found at Pittsburgh International Airport. Investigators say Claudia got on a plane to New York on March 12th and eventually flew to Brazil. The Brazilian government renounced Claudia's citizenship, allowing her to be extradited to the U.S. in January 2018, 11 years after Carl's death. She faces life in prison without the possibility of parole. For the Law and Crime Network, this is Aaron Keller.
All right, thanks, Aaron. We're going to be live in that courtroom at around 1 p.m. Eastern Standard Time today. And guess what? The defense is going to begin their case. Let's break it down right now with criminal defense attorney and former prosecutor Philip Holloway. Philip, great to have you here on Law and Crime.
Glad to be here. Good morning.
Good morning. Now, I got to ask you about the defense's case here. We believe that they are going to put Claudia Herig on the stand. What's your thought on that?
Well, you know, anytime the lead lawyer for the defense comes out early on and says, you know, my client will testify, of course, the jury is going to be hanging on that anticipation. They're waiting on that to happen. Whether or not it actually happens, however, is always an open question because things happen. Defendants change their mind. Now, in this particular case, I'm not so sure she will change her mind. She's been a prolific jail mail writer, so to speak. She likes to get her side of things out there, and I think it's probably a fair bet that she will testify. But that could always change. And anytime I hear any lawyer, whether it's a prosecutor or a defense lawyer, saying this is what a witness will say, and the jury's taking notes, if the witness does take the stand and they say something different, or if they decide not to take the stand, the jury is going to remember that, and that gives the other side the possible opportunity to stand up in closing arguments and say, they told you were going to hear this, and you didn't hear that, so why not? So it's always potentially beneficial, but there's always a risk. So, of course, we're going to have to wait and see if she actually does testify. It's certainly going to be interesting.
Well, as you said, she's been very vocal, complaining everything about her extradition to jail conditions. But before we even get to the defense, let's start right now with the prosecution's opening statement from the beginning of this trial, and you'll see which way they were going. Take a look.
And a statement that puts blame on everybody else but herself. She comes up with endless inconsistencies, unsupported with corroborating evidence, circumstances, and frankly, attacks on her deceased husband. While he's preparing to leave her, she's preparing to kill him that weekend. she's actually on Saturday going to the Slug Master's shop in Braceville, which is not far from Newton Falls, and she had been there previously, looking for a weapon. She's looking for a weapon with hitting power. She wanted bullets that would expand, hollow ones. And on Saturday, she goes and purchases a Smith & Wesson .357, 5-shot. And Mr. Becker will introduce the witness.
Okay, that's the prosecution saying how this was a cold-blooded, prior calculated murder. Now, Philip, I got to ask you, we're talking about an 11-year-old crime, or murder, or killing at the very least. Is this a hard case to prosecute?
Anytime you have that length of time that passes between the event, in this case the alleged crime, and the prosecution, there's an opportunity for a lot of things to go wrong that could run the prosecutor's train just right on off the tracks. And what we have seen in this case, just by way of one example that I can point to, is they have enough time has passed that the lead detective in this case has been convicted of a crime. And it's not just any crime. It's a crime involving moral turpitude. It was a theft, right? And this came out on his cross-examination. So that bears directly on his credibility. And anytime a witness of any type sets foot in the witness chair, their character for truthfulness is at issue. So anytime you've got 11 years, 10 years, 5 years, whatever the case may be, if you have a significant period of time that passes between a crime and the prosecution, then things like this can go wrong. And all this jury needs, remember, is reasonable doubt. The prosecutor bears that burden, not the defense. So if they can identify just one or two or three things that the jury can hang their hat on, that could amount to reasonable doubt. Let's not forget in this case, they are not basically saying she didn't do it. They're basically saying, from the defense perspective, that it wasn't a murder because of her state of mind. So all the jury needs is just one little sliver, and if it's that witness's credibility, then they've got their sliver of potential reasonable doubt.
See, now this is why you're so good on the Up and Vanish podcast, giving that other perspective right there. And that's really important. You talk about the defense. Let's take a break. When we come back, we're going to hear from the defense's opening statement. We'll be right back. Again, the defense is saying that this wasn't planned out. This wasn't like a classic case of murder. This was a heat-of-the-moment kind of thing, and she reacted, maybe in a moment of weakness, and that's really what they want the jury to understand. Let's continue a little bit more with the defense's opening statement from when this trial first began.
Put on a plane. Flown back to Ohio on the plane voluntarily. Told the marshals her story. Came back here, sat down. You're going to hear, you're going to watch. She sat down with the detectives. You're going to watch. She spends a half an hour or so. You're going to see in the video telling them she really doesn't want to talk about what happened. She doesn't want to give them all the information because she doesn't want to hurt Carl's family. She doesn't want to impugn the dead man. Before finally she talks for about 3.5 hours. You're going to hear throughout that statement, Marshal Bolton repeatedly say, well, yeah, that's exactly what you told us on the plane. And that's the evidence you're going to hear. As Miss Herig told you herself, as she will say herself on the thing, Carl Herig is dead because she shot him. And she shot him because at her moment of weakness, 30 days after she's attempted suicide, when she wants to have a conversation with him, he tells her, go ahead, kill yourself. Just do it in the basement so you don't get my stuff messy. Ladies and gentlemen, that's the evidence you hear. That's why the lie is so important in this case. You won't hear any evidence of premeditation, planning, or design.
Okay, let's break this down. Philip, that last moment that the defense attorney explained, if in fact Carl Herig made that statement to her about, hey, you want to kill yourself, do it in the basement, is that enough to cause, by a legal standard, provocation? Is that enough to say, hey, wait a minute, that may have caused something in her to pull the trigger, and that's not quite murder, it's maybe something less?
See, this depends on exactly how you view that statement. Could it be provocation? Possibly. But could it also be motive for murder? The answer has to be yes. We all know that malice, if you will, malice of forethought doesn't have to be something that's planned out over minutes, hours, days, weeks, months, whatever. It can be formed in an instant. So when they say, ladies and gentlemen of the jury, this was a snap decision, something that just happened in the spur of the moment, well, what they're doing is they're trying to get the jury to get inside her head and accept that she was sufficiently provoked. Now, because you're mad with somebody because they have said something to you that was angry or hurtful or something you didn't like, that does not necessarily rise to the level of sufficient provocation, that heat of passion that would make it basically irresistible to keep you from pulling that trigger. The classic example that is taught in law schools and the examples that are given are where, a spouse comes home to find a cheating spouse in the heat of passion with somebody else other than them, and they just, pick up the gun that's laying by the bed and pull the trigger. Whether or not these angry words, these fighting words are enough is ultimately going to be a question for the jury to decide. So it's understandable that each side is focusing on her state of mind, and in the end, it's going to be, of course, a question for the jury. What was she thinking when she pulled that trigger?
And maybe they'll get a sense of what she's thinking if she does take the stand today. We believe the defense will begin their case a little bit later on. We believe a live feed will happen at around 1 p.m., and maybe she will take the stand. In the meantime, we're analyzing different aspects of this case, and we'll focus more about these legal distinctions when we come back, because when we come back, we're also going to talk about her extradition. We'll be right back. Stay tuned. All right, there's a whole separate discussion about why she opened her mouth and just kept speaking to these federal authorities without, having a lawyer present, but that's not the question. Philip, my question to you is, the idea of her maybe being suicidal, and if the jury ultimately believes this, how does that affect their determination about whether or not this was murder?
Well, that's a very difficult question for me to answer definitively, but what I can glean from all of this is that this is more efforts quite frankly, by both sides to try to take the jury inside her mind at or near the time just before and just after this shooting took place. And, I've got to ask the question of myself, when I'm hearing this testimony about her being suicidal after the fact, how does that help me understand what was in her mind before the fact? It's not unheard of for people to commit murder and then decide they're going to kill themselves. Murder-suicides, unfortunately, happen all the time, and particularly between spouses and people who live in the same household, unfortunately. So I'm not quite sure how this can conceivably help the defense, although I suppose there's an argument that could be made in support of that. But the bigger question, to your point earlier, is what is the accuracy of these statements that were made to this FBI agent? Because he appears to be, relating this from memory without using his notes. And were these things recorded? Do we have it in writing? Was it on video? Is it audio? Lots of things. Anybody who's ever played the game of telephone where you say something in somebody's ear and just, pass it down, we all know that things can get lost sometimes in the conversation or in the retelling. So I'd like to know exactly what her words were when she was making this statement to this FBI agent. And if we don't know exactly what her words were, why should we give this much weight at all?
Well, it seems the defense not fighting it too much, but, this Anthony Sano is not the only person that testified about the extradition flight. We also saw the testimony of U.S. Marshal Bill Bolden. Let's play some of that testimony right now.
As we continued on the lengthy flight, she began to tell her story, a version of events as to what occurred when she was involved or when she shot her husband, Carl Herig.
And tell the jury in your own words.
Objection. I'd like him to tell the jury in Ms. Herig's words what she said, not his own words.
Overruled. I think we all know where we're going. Let's proceed.
I noticed at the time it was approximately 6:52 p.m. when she made that comment. She made a variety of comments that were not in chronological order. She stated that she made a comment that she wanted to commit suicide and she purchased a gun to kill herself. She then told us that the gun that she had purchased to kill herself was the weapon that she used to kill Mr. Herig. She said that she did computer research on suicide and that research would be in the history on the computer that was found in the house. She made other comments about weapons recoil and that when people try to shoot themselves, weapons often recoil and they miss. Again, it was kind of difficult because we weren't asking her questions and I didn't have enough specific knowledge of what actually occurred in the house to even ask follow-up questions, so we were just letting her continue to talk.
And did she say what happened after she fired the shots?
Yes.
What?
She said that she went into her bedroom and attempted to kill herself, but that the weapon did not fire, and she did not. So she did not. She said that she went to the bank and withdrew money. She drove to the Pittsburgh airport, where she flew from Pittsburgh to New York City, and then she flew from New York City on to Brazil. She also made some type of comment that she had withdrawn $10,000 and sent it to her father in Brazil.
Okay, Philip, so there it appears he might be reading from notes to show his recollection of what happened on that flight. The bigger question is, when we talk about extradition, just to tell our viewers, this doesn't really happen like this, let alone in Brazil, right? I mean, this is a rarity to get somebody who was in Brazil, and under Brazilian law, she couldn't be extradited back to the United States to face criminal prosecution, but the highest court in Brazil was convinced that she renounced her Brazilian citizenship. This really doesn't happen often, does it, Philip?
No, it doesn't. And that's what they say in terms of the Brazilian courts. But, you've got to ask yourself the question, the pressure that was put on Brazil by, the United States government to release her, I guess there was, this talk of threat of international sanctions and withholding monetary aid. You got to wonder, did the court in Brazil create a legal fiction, or did they actually believe, that she had actually renounced her citizenship? There's no treaty, and so you've got to wonder if this is something that was sort of a special case for her because of this political pressure that was put out there. And yes, the officer in this case, just now that we saw, he was in fact looking at some notes, so it appears that he did take some contemporaneous notes of what was being said. Regarding her actual conversations with him, when I watched that, it made me wonder, why does she need to testify now? If basically her side of the event and what happened before and after, if this has already come out through these various witnesses, why does she need to testify? And if she does testify, she's potentially walking into a minefield of prior inconsistent statements, so that if her testimony varies one bit from any of this, they can use it on cross-examination to attack her own credibility, and it could potentially derail her entire defense. So if you've got all these statements out there and you're not really objecting to them because you think for whatever strategic reason it may help you, you got to ask yourself, do I really need to put my client on the stand at this point? If the jury's already heard all this stuff, why take the risk?
Well, it's ultimately up to her. It's her decision. And, she keeps fighting this extradition. She says that this was improper, that she shouldn't be here, that there's issues all throughout the justice system. Maybe she wants her day in court to be able to speak. Wise or not, we'll have to see what ultimately happens, because we do expect to be live in that courtroom today at around 1 p.m. Eastern Standard Time, and maybe we'll get an answer. In the meantime, let's take a quick break. When we come back, we have a lot more to talk about in the Claudia Herig trial. And that was the moment that he was killed. Philip, The idea that Claudia had made that statement to one of Carl's friends that if he ever leaves me, I'm going to kill him, and it's believed, as you can hear from family and friends, that Carl was going to leave her, was in the process of leaving her, and then she shoots him. Uh-oh, if you're the defense, how do you argue that this wasn't a pre-planned murder?
You know, I guess the best you can do sometimes is the best you can do, and sometimes it's don't believe what you hear, ladies and gentlemen of the jury. Sometimes that's the best you can do. But if the jury does believe this, and let's keep in mind, we all know and we've heard, you know, anything you say can and will be used against you in court, and it doesn't matter if you're saying this to other people, if you're saying this to the police, or if you're saying it to your friends or coworkers. Anything you say can and will potentially be used against you in court. And her statement, if she said it, that if he leaves me, I'm going to kill him, that is very damning evidence, and it may be something that, quite frankly, the jury can use to hang their hat on. If they're in the jury room, I can envision a situation where they're trying to decide, okay,
right,
what was in her mind? They've muddied the water, and we're trying to say, was this manslaughter? Is it murder? Was there this malice of forethought?
That might be the tipping point. That might be the tipping point ultimately. And Philip, we are going to talk more about this case later, but when we come back from our next break, we're going to focus on Jason Van Dyke. So stay tuned. We'll be right back. Welcome back to Law and Crime, everybody. I'm Jesse Weber, and thanks for joining us here on the program. We have a lot to cover today, so let's get started right now. Okay, right up, we are going to be live in one of our main trials in California. This is the Charles Merritt case. We're going to be back live there at around 12 p.m. Eastern Standard Time. This is the McStay family murder case, a case that's really captured the entire nation's attention, but we've been focused so much on it here on Law and Crime. In case you don't know too much about this trial, here's a special report talking a little bit more about it.
Charles Merritt is facing murder charges for allegedly killing a family of 4 and burying their bodies in the desert. Joseph, Summer, Gianni, and Joseph McStay Jr. vanished from their Southern California home on February 4, 2010. Police found no evidence of struggle or foul play, but did identify signs that the family left in a hurry. The family car was found 4 days later abandoned at the Mexican border with no sign of the McStays. Law enforcement eventually believed the family fled to Mexico. Surveillance video at the border showed a family of 4 resembling the McStays crossing the border on foot. Officers also found search history on the family computer about travel to Mexico and passports for children. But a grisly discovery came nearly 4 years later when an off-road motorcyclist discovered the partial remains of a child's skull on the outskirts of the Mojave Desert. A search revealed 2 shallow graves containing the remains of 3 more bodies. DNA and dental records matched the bodies to that of the McStay family. A 3-pound sledgehammer was buried with the bodies. The family had been bludgeoned to death, according to prosecutors. As law enforcement was investigating the McStay's family disappearance, San Diego detectives interviewed Charles Merritt, a business partner of Joseph McStay. According to the affidavit, it was determined that Merritt was the last person to see and talk to Joseph alive. The two had met at a fast food restaurant before the family went missing. The last cell phone activity on Joseph's phone was a call to Charles Merritt. Merritt's DNA was also found on the family car abandoned at the border on the steering wheel, the gear shift, and the radio. He claimed he never driven the car, but rode in the passenger seat with Joseph 6 weeks prior to when the family went missing. Charles Merritt is pleading not guilty to the charges. Defense attorneys are pointing to another business associate as a possible suspect. Merritt is facing 4 counts of murder. For Law and Crime, I'm Rachel Stockman.
All right, thanks so much, Rachel. Now, again, we expect to be live in that trial around 12:30 p.m. Eastern Standard Time. As soon as we have an update or a court feed, we're going to make sure to go there. Right now, though, let's talk about Jason Van Dyke. Friday was a huge day in this saga. As you remember, we covered the trial of Mr. Van Dyke, who was found guilty of second-degree murder and 16 counts of aggravated battery in connection with the shooting death of 17-year-old Laquan McDonald. Now the question became, what would his sentence be? the judge had a lot to consider here. He had to listen to the prosecution's argument, the defense's argument, witnesses by the state that were presented in terms of people who had experiences with Van Dyke, and then the family and friends of both Mr. Van Dyke and Laquan McDonald. Let's start right now with the prosecution's argument from Friday.
Your Honor, there are primarily three areas that you should look at when you're determining the possible sentence in this case. First, obviously, is the jury's verdict. Second is the criminal code corrections. But third, and importantly, and I'll address this here in a moment, is the indictment. All of these three areas need to be considered, given your experience and the precedent and direction that we have in both the appellate and Supreme Court. I talk about the indictment because the indictment sets forth not just the allegations, but the intent as reflected in the murder counts and the 16 separate counts of aggravated battery with firearm official misconduct, and how we then presented the evidence through those counts beyond a reasonable doubt. We presented that evidence through detailed trial testimony. I want to talk about three particular areas. The first was the video evidence that showed 16 separate and distinct acts committed by the defendant. It was very clear. There were video evidence that was highlighted, it was broken down, it was slowed down, that showed and convinced the jury beyond a reasonable doubt. But the Supreme Court has told us, they have told you and every court in this state, that the trial judge is in the best position to make that determination. And not every gunshot that strikes a human being equates to severe bodily injury. We set out kind of a survey of some of the cases that we were able to find that found severe bodily injury and gunshot wounds that struck a human being that did not cause severe bodily injury. My point, Judge, is that you're in the best position to make that, given not only your position here in this case, but your experience hearing cases, and your decision, according to the Illinois Supreme Court, is entitled to and will be given and should be given great deference, to quote the Illinois Supreme Court.
So the prosecution ultimately recommended 18 to 20 years, and we're going to talk more about that. Joining me right now is criminal defense attorney and former prosecutor, as well as former police officer and a legal advisor to a sheriff's office in Georgia. Philip Holloway is back with us. Now, Philip, I don't think you and I had ever had an opportunity to talk about the Jason Van Dyke trial, so I'm just curious from an overall perspective, what was your view on this case?
This was a tough one for me, and let me explain why. In hindsight, looking at the video and all of the information that we've subsequently learned, I'd like to think that if I were in the officer's shoes, I would not have taken that action. But this is the problem. The U.S. Supreme Court told us back in 1989, I believe it was, in a case called Graham versus Connor, that in looking at police use of force situations, we are not supposed to second guess this with the 2020 lens of hindsight. We're supposed to step into the shoes of the officer on scene, and keep in mind that's a dynamic, it's a fluid, it's an ever-changing sort of situation, and we're supposed to ask ourselves, would a reasonable officer, under the same or similar circumstances, if basically taken back in time and transplanted into his shoes, would that reasonable officer, this hypothetical reasonable officer, would they have done the same thing? And if the answer can be yes, then that really is supposed to be the end of the inquiry. So you have a situation where you do have someone who was apparently armed, and of course we're seeing the video now on the screen, and it's obviously a dynamic and fluid situation. And I've questioned what I would do in that situation with the 2020 lens of hindsight, and I don't think I would have pulled the trigger like that. But I've also questioned whether or not it may have been better to have a bench trial in this case rather than a jury trial, because oftentimes, whether it's these police shootings or any other kind of case, the danger is that juries will decide these cases based on emotion, and jurors are supposed to leave their emotions outside the courtrooms. Sometimes these things are better left decided by a judge who presumably would not be swayed by these emotional sort of considerations that are always front and center with these trials.
Funny you should mention the judge and how it might be interesting if they had a bench trial, because in light of what the sentence ultimately was, and many people view that almost 7 years in prison, the sentence that was ultimately imposed it was pretty lenient. Would it have been better for Van Dyke to leave the guilt or innocence, the not guilty or not guilty phase in the hands of the judge?
Yes, that's the question, and I think the answer may very well be yes. Obviously, the trials that were bench trials related to the other officers, those were different legal issues, and so I don't know that we can say because of what happened to the other officers and their acquittals means that in this particular instance there would have necessarily been an acquittal. But I do think that you have to consider, since this is really a legal question and it's not really anything more than a legal question. There's no doubt that he pulled the trigger. There's no doubt who did it. You don't have a lot of those considerations. The only thing that a trier of fact, whether it be a judge or a jury, has to do is to apply the legal standards as set out by the Supreme Court. And whether it was reasonable or not at the time is the only key question that the trier of fact has to consider.
Well, I'll tell you
emotional
what,
considerations don't matter.
Phil, I'll tell you what, maybe we'll ask that question about whether or not a bench trial was ever thought about when we interview a little bit later the defense attorney for Jason Van Dyke. We expect to interview him at around 11 a.m. Eastern Standard Time, and maybe that's a question that will be asked. In the meantime, let's take a quick break, and when we come back, we're going to hear the defense's argument during the sentencing phase. We'll be right back. Okay, in an effort to get the most minimum sentence possible, what the defense is basically arguing is that, yes, he's charged with second degree, he was found guilty of second degree and aggravated battery, but really you should just find him guilty, you should just sentence him on the second degree. Now, Philip, the judge agreed, only sentenced him on second degree, didn't even sentence him on aggravated battery, and we know that the minimum for second degree could have been probation. Do you think that was the right decision by the judge to accept the defense's argument?
I don't think there's any question but that it was the correct decision for the judge to make, because as a legal matter, those lesser includeds do merge into the murder count. So there can be no sentence on that. I think that's really a no-brainer in my view. The real question, though, for the judge is what to do about the greater charge, the murder.
Right.
They could have, of course, asked for straight probation. I think it makes sense not to, because if you want to get the judge to come over to your way of thinking, you can't ask for anything that's really unreasonable. So it may be second degree, but it's still murder, and it may not necessarily be reasonable to ask the judge for straight probation. He's been in jail, so there's going to need to be some incarceration period there, and he's going to be eligible for parole as well.
Yes,
so all those things have to play into consideration.
And that's what he ultimately considered, and we're going to talk more about his verdict a little bit later on, but before we even get there, let's move into some of the witnesses that were called to the stand during the sentencing phase. Let's start right now with Vidal Joy.
To August 10th of 2005 at about 10:50 p.m. Do you recall where you were at that date and time?
Yes, sir. I was at the gas station going Cermak. I was coming out the gas station.
So you were at the gas station at Cermak?
Yeah.
Cermak and what?
Ogden.
And were you in an automobile?
Yes, sir.
Now, Mr. Choi, was the defendant in a police uniform?
Yes, sir.
Tell the court, if you would, what happened when the defendant approached you.
When the defendant approached me with his gun drawn, he was shouting obscenities, racial slurs, or what have you. And the defendant, as well as he was accompanied by several other officers who was shouting obscenities to my acquaintance as well.
You recall specifically what words the defendant used when he was yelling?
Well, honestly, I can't recall because I was quite nervous because he had his gun drawn on me. Excuse me?
How close did he get to you with his gun?
He put the gun to my temple.
Okay, that's Vidal Joy testifying about a negative encounter he had with Jason Van Dyke. He testified in the sentencing phase. Let's see how he did under cross-examination by the defense.
Agree with me that you never told the investigator from OPS, the complaint, shortly after his incident, you never told that person that Jason Van Dyke put a gun to your head.
Sir, I thought that him pulling a gun during a traffic stop was excessive enough.
Not my question. My question, though, is you came here today and you testified to the two worst things that Jason Van Dyke did. He used a racial slur against you, and he put a gun against your head, correct?
Yes.
And you never told the investigator those two critical points that you're now here testifying to shortly after the incident happened.
I recall telling her that doesn't mean she recorded it.
Well, you signed it, correct?
Okay.
And you made notations on there, correct?
That she asked me to make.
Okay. Why didn't you put in there, hey, you didn't put in here the two most salacious allegations I made, that Jason Van Dyke used the N-word against me, and he stuck the knife or the gun to my temple. Why didn't you include that? Maybe because when I was being interviewed, that the interviewer acted like that she wasn't really interested in what I was talking about in the first place. And she was a female there, correct?
Yes.
Minority, correct?
Yes.
All right, that's Dan Herbert questioning the credibility of this witness, and we're going to interview Mr. Herbert a little bit later on in the program. Philip, I got to ask you, we know why these witnesses were called by the state to show the bad behavior of Jason Van Dyke for years, that he was racist, that he was aggressive, understand what they're doing here, but the defense is also questioning the credibility of this witness. How much does the judge, who's the sole decision maker here in the sentencing phase, how much does he really take into consideration these kinds of witnesses?
I have to think that unless they have ironclad proof that he's just some kind of monster who's had it out for minorities for an entire career, unless they can actually really prove that, I got to think the judge has to take that with something of a grain of salt. The judge has to consider the credibility of these witnesses and anything that's brought out on cross-examination. On the other hand, I'm sure this judge knows what those of us who've been in law enforcement know. There are some officers who are out there who are always the type who tend to throw gasoline on a hot fire, so to speak, and these situations sometimes become more violent and more tense than they sometimes need to be. In other words, they will escalate a situation where they might be able to de-escalate it. And I think that's what the prosecutor's trying to paint him as. But the defense, as you point out, is doing a fairly decent job of trying to mitigate some of this. Now, keep in mind, the judge did sentence him to some period of prison time. That's nothing to ignore. So I've got to wonder if some of this information did not strike a chord, at least to some degree, with the judge when he gave him this sentence. It wasn't what the prosecutor wanted, but it was still a fairly hefty prison sentence.
Yeah, there are others who say, hey, well, listen, he's never going to be a police officer again. There were those who are supporters of Van Dyke and say, hey, that's his punishment. He's already served some. He's been in jail for a while. He's never going to be, in prison again, but he's never going to be an officer again. And they'll say that the almost 7 years he was sentenced to prison, it's too strict. I mean, what would you say to those people? Because there are people who support Van Dyke and say, hey, listen, he should have just been sentenced to probation. He should have served no jail time. What would you say to those people?
Well, I can look at it in the context of my own career, and I've had one case where someone was charged with murder, and they wound up doing a special type of a plea to a lesser charge, kind of similar to this, and we were able to convince the judge to give straight probation. But that is virtually unheard of when you've got a criminal homicide, okay? It's
right.
Virtually unheard of. In my particular situation, the judge actually believed the person was innocent, so it was a little bit different situation. It's almost unheard of to get straight probation in a criminal homicide. There's going to be some type of incarceration. He's been in jail now for some period of time. He's going to get credit for that. The judges also have to think about, the likelihood or the possibility that he's going to get parole. And you've got someone who doesn't have a criminal history, so I think it's fair to say he's going to be eligible for and most likely would get some period of parole. All of those are things the judge has to take into consideration, and I think the judge did so.
Yeah, I couldn't even imagine what the reaction would have been or how you even justify it if it was if he was sentenced just to probation, I mean, the outcry, I mean, there are people who are really upset about the almost 7 years, 6 years and 9 months, but if he had just gotten sentenced to probation, you can only imagine what the outpour, the reaction would have been. But let's take a quick break. When we come back, we're going to play the testimony of Edward Nance, really compelling testimony from Friday about his interactions with Jason Van Dyke. We'll be right back. Welcome back, everybody. We're still talking about the Jason Van Dyke sentencing verdict from Friday. Really incredible day in that courtroom. Emotional testimony from both sides, particularly the family of Laquan McDonald and Jason Van Dyke testifying. But before we even get there, let's move back to the people who testified about their highly negative encounters with Jason Van Dyke. And we want to move now to Edward Nance. He was pulled over by Jason Van Dyke. And really, just take a listen to what he had to say in the courtroom.
Where did you pick Carlton up from?
A day ran.
Could you say that again, please? I couldn't hear you.
At the day I ran on 87th Street.
Okay. And was he working, or did you pick him up from his home?
No, he was coming to visit me. He was coming from the west side to visit me.
So you picked him up, he gets in the car that you're driving, which is your mother's.
Yep.
And where were the two of you going?
Back to my house in Merritt. Threw me face first on the car, and then put a handcuff on my arm, and then he grabbed my other arm, and they pulled it around and put the handcuffs on both my arms.
After he put handcuffs on both of your arms, what happened after that?
He said, "What the fuck is wrong with you, motherfucker? I told you you got the car." And I asked him, what you stopped me for?
Did he respond?
Yeah, he said something. But after that, he turned me over and slammed me face first onto the car. And that's when they started taking my cousin out of the car.
All right, Philip. So Edward Nance and Vidal Joy are just two of several witnesses that testified about their negative encounters with Jason Van Dyke. Now, if all of this is true, is this standard protocol for how officers are supposed to respond, or does this show a level of aggression, particularly toward people in the African-American community?
Well, Jesse, I think they're trying to show that he had some particular animus towards African Americans, and that he was just generally speaking a more aggressive police officer. What I would, if I were the judge, what I would be more interested in seeing was whether or not there was any confirmed issues in his prior employment. His personnel file certainly is in the possession of the teams, both the prosecutors and the defense counsel. I would be very curious to know what in his personnel file, if anything, supported these types of claims that he just generally speaking was an aggressive officer who had an animus towards African Americans. If there was something that was investigated by Internal Affairs previously and it was confirmed, that would carry a lot more weight, because I'm willing to bet money that you can go out and get people who will come to court who just generally believe they've had a bad experience with a police officer, and they're going to come to court and they're going to tell you that. Now, I'm not saying they're lying, but I just think that it goes with the territory of a police officer. You're going to make some people angry, and if you later stand trial, you run the risk of bringing in everybody you've ever written a citation to who didn't like the encounter.
You know what? You might
that's the other side of that.
You might be very right. So let's see what the defense attorney did when they cross-examined Edward Nance, and maybe that's the tactic they went with. Let's see what happened under cross-examination.
How you doing, Mr. Nance? Mr. Nance, you're very emotional, and I don't want to. I'm not casting any aspersions on your emotion, but my question is, did you take all that medication that you spoke of? Did you take that today before you testified?
I took an anxiety pill about when we first got here, so because when I walked in, I didn't want to.
How many pills did you take today?
I take my anxiety pill, the clonazepam, and I took an ADD pill. I took a half of an ADD pill, and I took a half of a hydrocodone for my shoulders.
And is that a dose that you normally take, or did you take more because you were coming in as a test?
No, I had to calm down. The anxiety pill helps me calm down. The ADD pill helps me focus, and the pain pill is for the pain.
Okay. So the medication that you took for anxiety and the ADD, you took that because you were coming in there to test, correct?
I took it because I got emotional outside talking to the young lady that brought me in, talking about what I had to do today and coming ahead today.
Okay. Is this a normal occurrence for you to be this emotional?
Stressful times, yes.
Stressful times in your life, correct?
Well, every day I take the same pills once or twice a day, depending upon the dosage and the frequency that I have to take.
And you talked about some of your conditions, anxiety, PTSD, ADD. You've been diagnosed with those from before your incident with Jason Van Dyke, correct?
No.
Is it your testimony that what Jason Van Dyke did to you resulted in you having ADD?
Yes.
And PTSD? You had no symptoms of PTSD prior to the incident with Jason Van Dyke? Is that your testimony?
20 years ago, I was in the Army. I enlisted in the Army. Something happened to me when I first got to the Army in '88. But I wasn't taking medication.
Okay, Philip, tricky cross-examination. What did you think of the defense's strategy there?
Well, it sounds to me like they were listening very carefully to the testimony, and they picked up on some nuggets that he gave them, particularly with regard to explaining his emotional demeanor on the stand. That actually jumped out at me also as something that I might want to explore on cross-examination, so I think they did the right thing with it. It doesn't necessarily, to me at least, ring true that you're going to develop attention deficit disorder by virtue of a traffic stop that you disagreed with a police officer, even if it was one who used bad language and was overly aggressive with you. And so it doesn't seem to make a lot of sense to me why he would claim that he got attention deficit disorder, and maybe that factored into the judge's decision about whether or not he gave much weight, if anything, to this testimony.
And remember, it's all up to the judge to decide what the sentence will ultimately be and how much weight to give each one of these witnesses. And speaking of witnesses, when we come back from our next break, we're going to play you the testimony of Reverend Marvin Hunter, who is Laquan McDonald's great uncle. Stay tuned here on Law&Crime. Back to Law&Crime, everybody. As we continue our discussion of the Jason Van Dyke sentence, we're playing you some testimony from Friday that you may have missed. And right now, let's play Reverend Marvin Hunter, who is Laquan McDonald's great uncle. He took the stand Friday. Let's listen to what he had to say.
The victim impact statement that you prepared for this case, correct?
Yep. Yes, sir.
Are you prepared to read the victim impact statement?
I am.
Please do so.
The saddest part of this ordeal is for my mom and my sister. My mother, who had worked very hard to overcome drug addiction and learn the skills of being a responsible parent, was only weeks away from her, myself, and my sister to be reunited as one family in our own house, with my mom being the head of the house and my sister and I being the children. I was so happy for the possibility of that day. However, Jason Van Dyke, with his cold callous and disregard for the life of a young black man with a young black man without me provoking him, robbed us of this. In the short time of my life, I have worked hard to correct the mistakes that I had made, but in a matter of 6 seconds, he then took 16 shots and ended the possibility of this happening forever. From the time of my birth, my mother, sister, and myself lived with my great-grandmother. And under this kind of situation, the great-grandmother was the mother to all, but in a house with my mother, my baby sister, and I. I would have had my own room, my sister, her own room.
Okay, well, after family and friends of both the defendant and the victim testified, the judge ultimately sentenced Jason Van Dyke to 81 months in prison. That's 6 years and 9 months. Back here with Philip Holloway. Philip, how did the judge come to that sentence?
The judge has to take into consideration not only the evidence that he heard during the trial of the case, but he's got to take into consideration factors that are what we call aggravating circumstances as well as mitigating circumstances. What we've seen here with these last several witnesses is the prosecutor's attempts to put up aggravating circumstances in a way to persuade the judge towards that higher sentence. Now, what the judge actually gave was much lower than what the prosecutor wanted them to give. So I think in terms of the sentencing, if you can say there was a winner, I would say that the defense won the sentencing because there really is not a lot to use beyond the actual facts of this case. Obviously, family members are always going to have a lot of pain, and they're going to come to the witness stand, and they're going to bring that pain. They're going to express that. So that is something that's to be expected. Now, what we didn't see is that we oftentimes see in other cases is prior convictions, you know, somebody who's getting in a fight at the jail.
We don't really have that in this kind of case. Philip, I'm sorry to cut you off. We do have to hit a break. I know our time's limited. Thanks for coming on. But when we come back, we're going to have an interview with Jason Van Dyke's attorney. Stay tuned.